Welcome to the EPG Pathshala. This paper is the philosophy of law. The current module is on the treatment of caste under Hindu law. The objectives of this module are to understand the nature of caste discrimination in relationship to Hinduism as a religion and the laws that have been put forward to deal with it. This paper was written by Garima Goswami, an independent research scholar in New Delhi. I'm Akash Singh Rathore from the Lewis University of Rome. The significance of Hindu law is immense when you consider that Hindu law takes shape as family law within the Indian legal system, and that family law governs marriage, divorce, succession, adoption, and many other matters. So it's important to understand what is the nature of Hinduism, what's understood to be Hinduism in relation to Hindu law. There's a deep ambiguity about what Hinduism is, and this ambiguity has existed for millennia, and it continues today. The ambiguity arises because within Hinduism there aren't either texts or practices that everybody agrees are crucial to the centrality of the religion. In Christianity, for example, despite that there are many internal differences, the most salient one being the division into Catholicism and Protestantism, but then keep in mind that Protestantism is itself divided into innumerable other sects. Despite all of these divergences, there is a fundamental unity in the nature of the moment of the origin of the religion, in the birth and life of Jesus Christ, and in the centrality of the New Testament as the basic scripture that unites all of the different beliefs and practices. Now, these beliefs and practices are very divergent in terms of the interpretation of the significance of that central text, the New Testament. Some people emphasize certain aspects. Some people suggest that the meaning is different from what other people suggest. Some people suggest that certain moments after the life of Jesus are equally important to keep in mind. For example, the Mormons, who have different supplementary religious books to the New Testament. And despite all of these divergences, there are a couple of crucial factors. One is the moment of the origin of the religion, and the other is the centrality of the text. You can think of Islam as well, the salient division between Sunni and Shia, and of course the divisions internal to the Shiite religions, for example, the 12 Shias in Yemen, or the way that the religion is practiced in Iran versus the way that the Sunni religion is practiced in Pakistan, the prohibition of Ahmadiyism, and so on. So there are a number of internal divergences within Islam. And yet, despite all of these differences, both in practice and in supplementary literature that's considered crucial part of the religion, there is a moment of what we can refer to as the prophetic moment, or the moment of prophetic revelation in the life of the Prophet Muhammad, and the centrality of the Quran that is beyond dispute in all of these various interpretations. So I've mentioned both life and practices, for example, the life of Jesus and the Prophet Muhammad in Christianity and Islam, and the centrality of texts, so the New Testament for Christianity and the Quran for Islam. Now, Christianity and Islam have produced a number of other texts and a number of rival practices, how rituals should be performed, when they should be performed, and so on. But the centrality of the text is crucial. Now, Hinduism lacks all of these moments of cohesion. There isn't a fundamental prophetic moment. There isn't a fundamental text that can be agreed upon by everybody who practices it. And so the various practices that occur within the numerous sects and divisions that are subsumed under the category of Hinduism have nothing specific to point to indicate that at least we're grounded in something that everybody else agrees to. So despite how you interpret the New Testament, whether it allows, for example, homosexual relations or forbids homosexual relations, the Christians who are engaged in that debate are still focused on the centrality of a single text upon which they agree is authoritative. So we've lost an anchor in a specific text, and we've lost a way of justifying various practices in this basically federation of texts and practices that get grouped together under the term Hinduism. So this complication, this fundamental ambiguity in what Hinduism is, bleeds into the difficulty of understanding the nature of caste discrimination according to Hindu scripture. Some people might say that caste distinctions are inherent to what Hinduism is, and you can't have Hinduism without it. But which text do you point to in that case, and which text do you ignore in the process of pointing out some and downplaying the role of others? What we saw primarily in the very early 20th century was an attempt to overcome this deep ambiguity in Hinduism by producing what's referred to as Semitized version of Hinduism. By Semitized, we mean modeling Hinduism on Semitic religions such as Islam or Judaism, which Judaism also has a central text and certain central moments, for example, in the liberation out of Egypt by Moses. So the Semitization of Hinduism was a kind of project that began in the late 19th century and really culminated in the writings of Veer Savarkar in around 1925, 1927, with the publication of what's now known as Hindutva. So the attempt in the 20th century was to come to some kind of decisive agreement or statement on what is the central doctrine of Hinduism, what is the sacred books, and what therefore we can all agree are practices that can be defined as Hindu. That book, of course, is the Gita for Savarkar, but this is deeply problematic when you keep in mind that pre-19th and 20th century practices of Hinduism and literature that we group as Hindu has almost no mention of the Gita from the 12th to the 19th century. Now, some people argue that it's basically 6 so-called orthodox philosophical schools of thought that we group together as a textual foundation for what we call Hinduism. This could work as far as it goes, except that we have a basic problem that arises under the notion of Hindu law as we understand it and practice it today in India, which is that as per Hindu law, the definition of a Hindu actually includes Sikhs, Jains, Buddhists, non-Muslims, non-Christians, and non-Jews. Now, why do I say that's a problem? Because if we identify the 6 orthodox schools as being the heart of Hinduism, then the heterodox schools, which include Buddhism and Jainism, are automatically lumped together in the contemporary idea of Hindu. So once again, the only possibility that we have for a centrality of scripture, out of which we produce something called orthodoxy, right? The right beliefs. Doxa is belief, ortho means right. So the orthodoxy, the right beliefs based on scripture. The only way we can come to an agreement on what is Hindu scripture is basically according to the definition of Hindu under Hindu law, anything written in India. And that is not very clear and precise. Now, what is the nature of caste and caste distinctions within this very broadly understood sense of Hinduism as a religion? The appearance of caste is in orthodox and unorthodox scriptures or writings is heavily contested. Some people say that caste distinctions appeared as early as later Vedic writings. Other people say that these are clearly editorial, what's called redactions. So I think texts that were written in much later into the scriptures, since these texts were originally oral, when they were finally written down many centuries later, certain people who already had later beliefs, such as caste distinction, started to write their beliefs of that time into the scriptures that originated centuries before. So these are called anachronistic redactions. So the person who's writing puts something, attributes something to an earlier time, which is anachronistic because it actually develops in the time of the editing process. So we don't know if it's true that the Vedas had any mention of these distinctions of varna or as we sometimes say caste, and we don't know when these distinctions crept into the literature. We don't know when it crept into the Orthodox literature. We don't know when it crept into actual practices. By mentioning practices, I should make that distinction between orthodoxy, which I had mentioned as the right sort of belief based on scripture, and orthopraxy, which means the right sort of practices or the right sort of rituals. Now, orthopraxy is sometimes grounded in scriptural dictates. So many of the Vedas tell you how to perform rituals, but more often it derives just from custom. What practices were prevalent at the time. So the ambiguity about caste in terms of orthodoxy or its scriptural origins, or caste as it's practiced, are both heavily contested, both in sociology, in history and historiography and political history, and even economists have something to say about it, since the caste distinction obviously arose fundamentally as a division of economy and political society. Now, this division of labor, which seems to be embodied in the caste system, also had certain sorts of virtues associated with the different varnas or different social stratifications. This was referred to as varna dharma and swadharma. So the performance of duties that are fitting to your caste. Now, a crucial part of performing duties fitting to your task is to not perform duties of another caste. So on the one hand, to follow the varna dharma is both to excel in the virtues specific to your station, and also not to interfere or meddle with the virtues of another station, caste, varna, what you will. There was another aspect, in addition to this identity of your obligations to be self-referential, in other words, to be dedicated only to the duties and responsibilities to your caste. And that was obligations that are due, and that is obligations that should be performed by all of the varnas, irrespective of which one a person belongs to. This element of dharma is believed to have eroded slowly over time. The crucial notion in this idea of a duty of all castes to all castes was the one anchoring, according to many sociologists, that prevented caste discrimination from occurring, because the one duty that was due of all castes towards all castes was to not discriminate on the basis of occupation. If all castes have the duty not to discriminate on the basis of occupation, then it's hard to understand how, at least in terms of scripture and orthodoxy, it's hard to understand how caste discrimination can arise when it is the duty of a particular caste not to discriminate against another caste. Of course, the trick lies in the differences between orthodoxy and orthopraxy. So while I may have a duty not to discriminate against the occupation of a sweeper, I can certainly in my practice show that I have certain preferences for the occupation that is accessible to me and not accessible to that person. For example, in another varna of passing judgments. So the sweeper mustn't pass judgments, the person who passes judgments mustn't sweep, but each person has an obligation, according to the same code, to not discriminate against the other. Well, in terms of theory, this is fine. We've seen theories like this, for example, in the United States, called separate but equal, which is to say that everybody has a separate station, a separate entrance, a separate water fountain, a separate mode of transportation, but everybody is regarded as equal. In theory, it's fine. In practice, we realize that this is a vicious sort of segregation. The person who pointed out most clearly what sort of vicious practices this theory of separate but equal leads to was Dr. B.R. Ambedkar. Now, Dr. Ambedkar had most rigorously opposed the caste system on the one hand, and was one of the most outspoken scholars to indicate that the relationship of caste and Hinduism was an organic one. So it's almost impossible to be a Hindu without following caste. Now, many other of Ambedkar's contemporaries said, no, caste is has been perverted, that ultimately there's no problem with it in theory, but the practice over time has been corrupted into the vicious forms that it took in the time of Ambedkar's life. Ambedkar, however, attempted to show that the origins of caste are coeval with the origins of the consolidation of Hindu practices and rituals, and that federation that I had spoken about, with understanding which practices and texts get grouped together under the umbrella of Hinduism. And in Ambedkar's historical writings on the genesis of caste, he makes two specific points that are crucial. As opposed to this argument that I had just been presenting, that there is a dharma that is peculiar to a varna, and there's a dharma that is common to all of the castes, Ambedkar argues that in either case, the idea of varna itself has implicit within it inequality. So on the one hand, to have what Ambedkar called graded inequality, and on the other hand, to claim that it is the duty of each of these unequal castes not to be discriminatory against another caste is inherently self-contradictory. The second thing that Ambedkar tried to suggest was that we can see that the organic tie of caste and Hinduism is proven by the very fact that those heterodox schools which I had mentioned earlier on were movements not only away from the orthodox scriptures or groundings in the Vedas that were the precondition for a vague ascription of the term Hinduism. Not only were they moving away from these Vedic texts or the orthodoxy, they were also moving away from the orthopraxy, which is to say that in the origins of Jain and Buddhist thought, two of the heterodox schools, one of the fundamental movements was not just away from Vedic ideas, but away from practicing caste discrimination. So if the very origins of heterodoxy derive not merely as an intellectual argument against certain doctrines, but as a specific movement away or rebellion against the practices of caste, then Ambedkar argues that it shows that caste is somehow inherent to Hinduism. Ambedkar gives a few kinds of evidence, pieces of evidence for this sort of argument. One of them is, of course, to advert to the descriptions in the writings of Manusmriti. The Manusmriti shows more clearly than any other writing in the history of Hindu literature that the different castes are certainly not equal. What do we mean when we speak about equality? Well, one of the basic principles of justice is to treat equal cases in an equal manner. So like cases in a like manner. This is the definition of justice. Well, Manusmriti is full of differential treatments, differential punishments for the same crime under the same circumstances. So if a person from one caste should do the exact same, commit the exact same crime at the exact same moment as a person from another caste, they would be punished rather differently. If a Shudra, for example, Ambedkar points out, should even recite certain sacred verses of the Vedas, Manu had demanded that a hot iron coal should be shoved into his mouth and his tongue should be burnt off. If a Shudra should claim to know more about the Vedas than a Brahmin, then he should be tied. His body should be tied and ripped apart. Now, obviously, such explicit practices belie or show the lie about the idea that the nature or essence of the caste system was corrupted into a sense that each of the castes aren't equal when they should be. If you have unequal treatment for the same crime, you have an unequal status. And if you have an unequal status before the law, then by definition, you're not an equal person. This was one set of arguments that Ambedkar had pointed out. Another was an interesting textual study that Ambedkar had done in the Pali canon. So there were two particular suttas that Ambedkar had pointed out that show that even Buddha himself experienced not only the strife related to caste, because all of the early canon is full of cases where the Buddha would take into his group of students people from different castes who normally were not allowed to be educated or included into the Sangha. In the Ambatta Sutta, Dr. Ambedkar points out that Gautam Buddha is even treated with a certain amount of contempt by a Brahmin for pretending to have wisdom. In this sutta, what we find is that Gautam Buddha starts to debate on the nature of caste and on the ideas that support it, for example, birth and karma. And he starts to suggest that the idea of caste should be fixed after the completion of a life, to see how the person actually lived, rather than at birth, before we know whether that person will actually fulfill the role that's expected of him. The other sutta where Dr. Ambedkar indicates that Buddhism was not only a turn away from orthodox beliefs, but also practices related to caste, exhibits a dialogue where the Buddha engages in more or less a mimicry of the beliefs related to caste, and shows that they ring rather empty and hollow. And this starts what Dr. Ambedkar refers to as the Buddhist revolution in favor of fundamental equality outside of the Hindu orthodox belief in graded inequality. So Ambedkar's argument is very clear, that we have on the one hand certain people who say that caste is a corruption of Hinduism. For example, Mahatma Gandhi had mentioned that whatever virtues the Varnashram Dharma originally had were eventually corrupted by selfish people and malpractices. But Ambedkar's argument is caste discrimination is inherent to the nature of Hindu scripture and practice. So Dr. Ambedkar and Mahatma Gandhi were arguing about the nature of caste and its relation to Hinduism in an India that was in the process of being liberated from more than a century of British imperial rule. Much of the argument that Ambedkar and Gandhi had related to whether the British had done anything favorable with respect to the elimination of caste discrimination. Dr. Ambedkar was of two minds about this. On the one hand, he realized that certain steps that the British took, for example, moving a number of issues into the private sphere and reducing their importance from things that regulate all aspects of public life to simply things that regulate questions of family law, was a favorable move of the British. On the other hand, the British didn't really do much to prevent practices of untouchability, allowing untouchables to enter into temples, or allowing untouchables to enter into the army. So there was a great deal of contention over the way that the British dealt with the practices of caste, whether this was liberating for those who suffered caste inequalities, or whether they were just perpetuating the caste inequalities. And there are good arguments to be made on both sides. So within the British legal practice and juridical practice, in other words, in how they decided cases, judges would actually take the advice of pundits or shastris in any matter where questions of family law arose. So if there was a dispute about a marriage, if there was a dispute about a dowry, if there was a dispute about adoption, if there was a dispute about divorce, and so on, there is no uniform code according to which this case would be decided. If it were a criminal matter or a civil and political matter, obviously the uniform criminal code would be enforced by the British. But if it fell under family law, then the judge would call a priest to give counsel. Now, that meant that depending upon the orthodox or egalitarian beliefs of that particular priest, certain people would meet with justice and certain people would meet with discrimination. This was considered a policy of non-interference on the part of the British. They really didn't want to get involved in the internal disputes of Hindu religious practices and doctrines. But sometimes they did. They did on both sides of this debate. Sometimes the British judges would actually give injunctions that would disallow certain castes or communities from entering temples. In fact, there are even cases where a British judge offered damages, in other words, a financial reward to so-called victims of marriages whose marriage party was polluted by the presence of an untouchable among them. Now, Dr. Ambedkar thought this was a quite heinous thing for the British to do, especially when the British championed themselves as introducing egalitarian and rational principles into Hindu practices, for example, in the abolition of sati and so on. Now, all of these debates are being carried out in the time of Gandhi and Ambedkar, but we know one of the most profound fruits or results of these debates and these discussions, and that is, following independence, on the drafting of the Hindu Code Bill. The Hindu Code Bill was a very precious piece of legislature that Dr. Ambedkar put forward, and together with Prime Minister Nehru, he tried to push it through Parliament. There was a great deal of resistance from Orthodox and Sanatan elements in the Congress Party and in the Parliament, and because the Hindu Code Bill could not be passed, Dr. Ambedkar stepped down as the Union Law Minister of India. But despite that, Nehru had his hands tied a little bit between his admiration for what Dr. Ambedkar wanted to achieve through the Code Bill and the fact that many of these orthodox Hindus were supporting Nehru and held prominent positions in government. Nehru managed, by breaking down the Hindu Code Bill into several smaller parts, he managed slowly to push these through Parliament. It took shape in 4 separate acts. Now, the reason that this is important is because through each of these acts, some element of caste discrimination that was either tolerated or in some cases mandated by Hindu law was systematically undone. So, for example, one of the acts prohibited polygamy for everyone who fell under the category of Hinduism. And the reason this is important is because under the previous practices, polygamy was permitted, but on a graded scale. So, for example, a Brahmin was allowed 4 wives, 1 of each caste, but a Shudra was allowed only 1, and it had to be a Shudra. So inequality would be built into these marriage rules. Another one of the bills into which the Hindu Code Bill was broken down permitted the adoption by any caste of a child of any caste. Now, this had not been allowed before. Prior to the Hindu Code Bill, customary practices of Hindu law prohibited Shudras from adopting higher caste infants or children. So this was another aspect that where the reform of Hinduism through the Hindu Code Bill made a disentanglement of caste discrimination from the idea of Hindu religious practices. Another case was the ability for Shudras to inherit property. So the Hindu Code Bill saw to it that Shudras had right of succession and right of inheritance that was previously denied to them through Hindu customary law. And of course, consequent upon all of these elements, these radical revolutionary elements that were introduced in the reform of Hinduism through the Hindu Code Bill, this paved the way for a number of other very important policies, laws, and acts to come into effect, such as the prohibition of prevention of atrocities in the Scheduled Castes and Scheduled Tribes Act of 1989. Now, what's the upshot of all of these permutations that have occurred in the understanding of Hinduism in the attempt to turn Hinduism into one coherent body of doctrine, and at the same time to ensure that caste is separated from that one body of doctrine? Well, we see that this happens decisively through the passing of the Hindu Code Bill, because there we have a concrete understanding of what Hinduism is and who is a Hindu, hand in hand with a deep prohibition of discriminatory practices of caste. So what couldn't be accomplished either through philosophical schools of thought or through priestly assertions about what is crucial or central to the religion, or of the various practices of different sects, what could never be accomplished by any of the priests, philosophers, or practitioners was actually accomplished, ironically, through the brainchild of Dr. Ambedkar with the passing of the Hindu Code Bill. That is to say, to come up with a central idea of what Hinduism is, and to make that central idea free of caste discrimination. I want to close with one particular High Court case that I think beautifully exemplifies this long historical process. The case which I would like to close with is called Singh versus Mathura, which occurred in the Madras High Court, where a high caste, in fact a priest, had decided that there was a particular person who happened to be to belong to a caste considered Shudra. But there was a particular person who was so learned and so devoted that this priest decided, while he was alive, that that this so-called Shudra would inherit all of his property. So he enjoyed the right of succession, which also meant that he was going to be leading a mutt. So the son, the natural son of the priest, took the case to court and said that according to the practices of Hindu customary law that their family has been following for generations, the right of inheritance is primogeniture. It goes to the firstborn male in the family. And not only that, not only is primogeniture important, but the person to whom the father has wrongfully given the birthright that should go to the firstborn son is a Shudra and has therefore no business being in control of a mutt. The court sided obviously in favor of the right of the father to donate his property to whomever he saw fit, but made the specific point of suggesting that as a consequence of the acts that were institutionalized through the breaking apart of the Hindu Code Bill, it is now the law of the land that if a former Shudra would like to be the head of a mutt, he has every right to do that, whether the authority comes to him from a high caste person or whether he should decide to start it on his own. So what we start to see in the 1980s is the actual implementation and institutionalization of the logic of a Hinduism that is free of the principles of caste discrimination.